As the probate executor or the administrator, one of your primary duties is to manage the decedent's assets. Now, today you're going to hear me refer to the executor or the administrator as the personal representative. Now, when you go to file probate, you're going to be given several forms to fill out. On one of these forms, there's going to be a section called the preliminary inventory list. And in this section, you will list the decedent's assets along with the value of the assets. Now, this list is called preliminary because there is an understanding that at this point, you may not know the actual value of the assets. So you may not have found out what is actually in the bank account yet, or you may not have had the house appraised or antiques or jewelry appraised. So you don't know what the true value is yet. So with the preliminary inventory form, you're going to give your best estimate of what you think may be in the account. Now, within 90 days of becoming a personal representative, you will have to fill out another inventory form, which is normally referred to as the 90-day inventory form. On the 90-day inventory form, you will list these assets again along with the actual value, because during the 90 days, you will have been given the authority to call the banks or to call an appraiser and find out what the true value of the house is, or what the furniture or antiques or jewelry is. So this is why on this form, they want to know the actual value. Now, when filling out either inventory form, the preliminary or the 90-day, it's important for you to know that not all assets have to go through probate. And it's important for you to understand which assets are included in probate and which ones typically aren't. In today's video, I'll share with you which assets you need to include on the inventory list and the ones which are usually left out of probate, so you can successfully complete the inventory portion of the application. Hi, I'm Denise Davis. I'm a North Carolina Realtor and a certified probate real estate specialist, and I help people who are going through the probate process, who needs to file probate, and who also has real estate to sell. Now, before we start, I ask that you please subscribe to this channel, hit that notification bell, and if you like the video, give it a thumbs up. Now, let's dive in. Now, in North Carolina, probate assets include any assets that was solely owned in the decedent's name. It was in his name only. This includes personal property such as bank accounts, retirement accounts, investment accounts, stocks and bonds, automobiles, boats, unconventional vehicles, furniture, antiques, jewelry, and accounts without right of survivorship. Now, let's take a look at the actual form. Now, the preliminary inventory section consists of 3 parts. Here's part 1, part 2, and if we scroll down some, there's part 3. Now, in part 1, they want you to list the assets that were solely owned in the decedent name. So if he had bank accounts or investment accounts that was in his name only, you would list that right here in this section. Now, to the right, you see that there's a column labeled market value. Now, even though it's saying what is the market value, it's asking for what was the market value on the date that he died. So, for example, let's say on the date that he died, he had $1,000 in his savings account. Even though he died, the money in the account may have still accrued interest, or maybe his paycheck hit a few days later after he died. But here, they only want to know how much money was in the account on the date that he died. And it's the same for the other assets. So for every asset, you will give a value, and that value needs to reflect what the value was on the date of death. Now, on the preliminary list, you will give your best estimate because, like I said earlier, you may not truly know how much was in his account or how much his stocks and bonds were worth. But on the 90-day inventory list, you will need to contact an appraiser or his account holder, such as his bank or the investment or retirement company, to get the actual value on the date of death. Now, question number 2 says, joint accounts without right of survivorship. So here they're asking you if he had an account with another person without right of survivorship. Now, just in case you're unfamiliar with what the term right of survivorship means, it means that there are two or more people who own the property or the assets together, so they are all co-owners. You will hear right of survivorship also referred to as joint tenancy with right of survivorship. Now, if one of the co-owner passes away, their interest automatically transfers to the surviving co-owners. Or we can say their share of the money automatically transfers to the surviving co-owners, just to help you better visualize it. And because of this, the decedent's share or their part of the money does not typically go through probate or become part of their estate for inheritance purposes. Now, if the account is without right of survivorship, which this is what they're asking for, if one of the owners died, then his heirs, or if he named a beneficiary, would inherit his portion instead of the co-owners inheriting it. So if it is with right of survivorship, his shares will go to his co-owners. If it is without right of survivorship, his shares will go to his heirs or his beneficiary. And if this is the case, that the account was set up without right of survivorship, the other owners would become co-owners with the decedent's heirs or beneficiaries. They would all own it together. So this section is asking, did he have accounts with other co-owners, but without right of survivorship? So if you're filling out this form, you have not been appointed as the personal representative yet, because you are applying to become the personal representative. So most likely the banks or whatever company you need information from will most likely not give it to you. So this is why you're going to give an estimate of what you think may be the value of the accounts. Now, once you have been appointed as the personal representative, you have been given the authority to call the banks or mortgage companies to request information about the decedent's account, and they should release that information to you. Just be prepared to provide the letters that the court is going to give you, as well as the death certificate. Now, once you have been authorized to contact the bank or the mortgage company or any of the creditors, you need to ask them or any other names on the account. If they say yes, ask, was the account titled as joint tenancy with right of survivorship? If they say yes, this means that the decedent shares would go to the other co-owner. If they say no, this means that the decedent share would go to his heirs or his beneficiary. This is without right of survivorship. Now, in this section right here, if the account is without right of survivorship, they want to know what percentage belonged to the decedent. Why? Because they don't want to include the money that belonged to the other co-owners. So if the decedent and his buddy opened up a savings account in both of their names without right of survivorship, and let's say he deposited $70 and his buddy deposited $30, in this column, you would put his percentage down as 70%. So I just want to emphasize again that it's very important that you know how your accounts are titled if you have an account with someone else's name on it. Remember, if it does not say joint tenancy with right of survivorship on it or anywhere on the contract, then most likely it does not have right of survivorship, meaning your portion would go to your heirs instead of the person you opened up the account with or say purchased the home with. So let's just say there's a lady and a man who have been dating for a while and decide to purchase a house together, and they pay no attention to how the deed is titled because they're so happy and excited about buying the house. The man also has children who doesn't like the girlfriend. Now, a few years later, the man dies. The girlfriend and the children are now owners of the house because they did not have the house titled as joint tenancy with right of survivorship. So his portion or his interest in the house went to his children and not his girlfriend. And because they already don't like her, they may possibly file a petition to partition, which could possibly force her to sell the house that she loves, or she may have to try to somehow come up with the money to pay them their portion. So it's really important that you understand how the account or title is created. So for questions 4 through 12, you would put what you think the estimate is for each thing if it applies. So like number 8, if the decedent didn't own a business or if he wasn't in any type of partnership, then you can just put NA for not applicable here. And number 10 is asking, did anyone owe the decedent money? So if he had loaned money to a friend, the decedent dying doesn't mean they're off the hook of paying him back. They are still required to pay the money back to his estate if the personal representative pursues it. Or let's say if the decedent was in a lawsuit and he won, but they had not paid him his money yet. The amount that he's going to receive from the lawsuit needs to be here. So now we're to part 2. Now, in North Carolina, upon death, real estate is automatically transferred to the beneficiaries or the heirs, unless the decedent stated in the will for the house to be sold or the sale of the house or land is needed to pay creditors. So both real estate and accounts with right of survivorship typically does not go through probate. However, in part 2, it is asking you list these items. So although these items typically does not go through probate, in cases where there's not enough funds from the estate to pay off creditors, the personal representative can petition the court to have these things pulled into probate to help pay the creditors off. Now, this isn't something that is automatic. The judge would review and decide if these things are truly needed to be pulled into probate. And in part 3, you have 3 questions to answer. Question 1 is basically asking you, was the decedent and a spouse married at the time they made a purchase, such as a house? Did they purchase it together while they was married? This is also known as tenancy by entirety. Now, there are some other things that are required to be titled as tenancy by entirety, but I will get into that into another video. Question 2 is asking, did he have accounts where he named a beneficiary? So if he had an account and he named someone as the beneficiary, you would check there are. If he did not, you would check there are not. And question 3 is asking, was the result of the decedent's death due to another person's carelessness or negligence? For example, he went into surgery, and because of the negligence of the doctor, they did something wrong, which caused the decedent's death. So if the death was due to carelessness or negligence, then you would mark there is. If that wasn't the case, you'd mark there is not. So completing the inventory list can be tedious and sometimes feel overwhelming. So to help the process go a little smoother and a little quicker, it would probably be best for the person who filed probate to be someone who knew about the decedent's assets as well as know about the decedent creditors. And when it comes to locating all the assets, you want to make sure that you check dresser drawers. You want to check the attic, the closets. You want to look in if he had a safe in the house or if he has a safe deposit box. You want to look in all areas possible to locate any assets or any information about assets, so those things can also be included in the probate process. Now, I hope this video has helped you to understand what assets are, what assets need to be included in probate, and how to fill out the inventory form. Now, before I leave, if you have any inherited property that has been included in probate and needs to be sold, or if you just own a house that's in North Carolina that you want to sell, then I want you to contact me. I would love to work with you. You can call me, email me, or text me. I'll leave all my information below. Until the next video, be blessed and don't forget to subscribe.